I believe this is the matter that we had earlier indicated, that after all these matters have been consolidated, directions have been given in these matters, specific directions need to be given for purposes of that matter. And for purposes of enabling those specific directions to be given, I want to point out three things. Number one is that we would need directions on when the first application that was to be done after the validity application is determined, when we are going to be had. That is issue number one. Issue number two, my Lord, that is important, is the fact that now that today the Honorable the Chief Justice has caused all of us to come on the basis of these other matters, the point needs to be noted that for purposes of the basis for all these matters that empanelment is done, the reason was that there were applications for conservatory orders. Those applications for conservatory orders were first certified as urgent and would be the first business of this court appearing there, assuming there is no other preliminary issue like recusal or other ones. Thirdly, my Lord, is this, that for purposes of those applications where conservatory orders were made, the conservatory orders may have been made in 2 or 3 files, but they conserve the status, quo that is cross-cutting in all the petitions that are before you. Apart from the fact that in that particular petition, the one that has conservatory orders, when this court, because all those applications were done on Saturday, the parties, starting at least with those that I represent, because of the nature of the proceedings that were there yesterday, we have not completed doing the responses to the applications by the Attorney General to lift conservatory orders. We could not be able to do the authorities for reasons that were indicated, and more importantly, my learned colleague Mrs. Kemodo, whose file has been consolidated, did indicate she has not even been served, and in that matter, she needs to respond and be heard. Therefore, my Lord, in considering this issue that is itching the group that wants lifting of the orders, I would like the court to give directions bearing in mind that the stakes of the parties, all the people who have filed petitions, is to ensure you are not faced with a fait accompli, where you are told we have already sworn Kindiki and you can go to hell. We do not want to be faced with a fait accompli situations. My Lord, it would be absolutely important that the subject matter is preserved, if not for any other day, until all the parties are before the court. Yes. Your Lordship. Your Lordship, there is Let's do this.
because of provided agenda for you cannot discuss it's not the time. You can still talk. You don't have opportunity. You don't make you need to work to discuss with them. You don't record them.
You might not be so happy you are using the power. Not so far.
And I don't think the application is very
we will proceed in these matters as follows. By tomorrow, we will issue comprehensive directions on various issues, but importantly, parties are already aware that there are two cohorts of matters. The first cohort involves the petitions which were filed challenging the happenings before the National Assembly. Those petitions will proceed as cohort 1. They are the subsequent petitions which were filed challenging what transpired in the Senate. That is cohort 2. By tomorrow, we will deal with the issue of consolidation. We are aware of the powers this court has on the issue of consolidation, just like how we exercised the powers yesterday. We may decide to either hear or give directions on the consolidation. However, we are in agreement that the next application in line can only be one, and it is the application for recusal of this bench. And that is the application which, after we do everything, tomorrow at 2:30 is up for hearing. If you intend to participate in that application, in the second cohort, that application is coming up for hearing tomorrow at 2:30. In the morning, we will deal with the issue